Hello, good afternoon, everyone. We're here today on episode 4 with my law partner, George Edwards. I'm going to change it up a little bit. I'm going to do the introduction, and then I'll hand it over to expert advice from George. So today, last week we were talking about civil rights under Section 42 U.S.C. 1983, and those are probably the cases which are most well known in the civil rights space. Today we're going to be talking about a little bit less well-known part of the federal jurisprudence. However, one which has been around just as long, and it's 42 U.S.C. 1981. So 1981 is a little bit of an odd part of the law. It does combine our law firm's experience in both civil rights law, litigation, and contract law. Okay. So I'm going to read it just quickly for the audience. 42 U.S.C. Code 1981, equal rights under the law. Statement of equal rights. All persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and properties as is enjoyed by white citizens, and shall be subject to like punishment, pains, penalties, taxes, licenses, and exactions of every kind, and to no other. And the rest of it goes forward, defines what make and enforce contract means, which is making, performance, modification, and termination of contracts, and the enjoyment of all benefits, privileges, terms, and conditions of the contractual relationship, protection against impairment. The rights protected by this section are protected against impairment by non-governmental discrimination and impairment under color of state law. So I read a lot of things there. I'm going to take just a pause. And really what we're going to be talking about is the most important concepts today, which is what does it mean to make and enforce contracts under this section, and how you can protect yourself if you believe as a minority that your rights have been impaired. And again, I say minorities, but this law has been applied by the courts even to give protection to white citizens if they feel that they have been racially discriminated against. Okay, So I'm going to turn it over to George and give some background as well on this.
Well, hello, viewership. Today we are talking about another exciting civil rights law that can be used in court, and it's probably one that you've never heard of. And my law partner just read it out for everyone. And there's a lot there, essentially. So bear with us. There's banging going on at our location, undisclosed banging, some sort of construction going on. Welcome to Houston. So 1981 cases. When would you use them? Why would you use them? And really, what good are they? Like, what is it going to benefit a claimant who files a case like this in court? First, as I said in episode 3, where we talked about 1983 civil rights cases, always navigate the court system with an attorney. It's so much better to just navigate with an attorney than without an attorney, okay? Because you're going to be in federal court, and there are certain rules and procedures of federal court that are not observed in, say, state court, that your attorney will be specifically aware of and can help you understand and navigate. So basically, you file a 1981 when you have an express or implied contract with, we'll say, an organization or an entity. For example, you go eat at a restaurant. You walk into the restaurant, you observe the menu, you make a selection from the menu, you pay your money, then your items are prepared and given to you. That's how most convenient or fast food restaurants are going to work, okay? When they give you your food, there's an implied contract there that you can enjoy your food at home, or you can stay in the restaurant and use their facilities and sit down, use their forks, their napkins, their bench, their restroom, use their facilities to do your to finish eating. Okay. But let's assume in this factual scenario, which is entirely hypothetical, let's assume that you get your items and then they ask you to leave, right? Or let's assume that, maybe they didn't prepare all of your items correctly. And so you're doing some discussion with the clerk about, hey, this doesn't taste right. Can you re-prepare it? And the restaurant's rep or the restaurant worker uses a racial slur and tells you, get the hell out. Okay. And this is, I'm sure, happened before, maybe not exactly in that sequence, but you get the general gist of what could happen. If you leave the restaurant, you'll have a cause of action under 1981 because you were called a racial slur. So you'll have the argument that you were denied the benefits and privileges of eating of a restaurant customer eating at that restaurant solely on the basis of your race, meaning that they didn't like what your race was, and so they eliminated you from the restaurant. And what's the evidence of that? They called you a racial slur. Okay, that's one pretty textbook example of what a business owner can't constitutionally do. All right. As a customer, you have a reasonable expectation of whatever you order, it will be prepared and brought to you as a reasonably prudent restaurant would do for any other customer. A restaurant can't discriminate and say, well, I'm going to prepare all of the Big Macs one way for one set of people, and then for people of color, I'm going to prepare all the Big Macs a completely different way. Everyone has to have access to the same Big Mac, okay? And so when you file the lawsuit in court, there are certain things that you are potentially entitled to if you're able to establish that by reason of your race, you were denied the privileges of that contract. Okay, one of the things you can get, obviously, your attorney's fees. That's important because your attorney will keep, an hourly tabulation of what he or she is putting in on the case. You can get what are called your compensatory damages, things like, well, what did you spend on the food? You can take it as far as trying to claim the gas that it took you to get there, if you had to go out of your way to get to the restaurant. And you can also get, in certain circumstances, what are called punitive damages, which are like penalty damages almost, okay? Meaning that it was the conscious object of the clerk when they called you the slur, in this example, to hurt you and to injure you and to get you the heck out. It was their subjective belief that they formed about you, that because you are of color, you deserve the slur and you don't deserve the food. Okay? If you can establish that, sometimes by, like depositions or by talking to former employees who used to work there, who know the particular clerk and know how they operate and how they work, if you can establish that, you could potentially recover 1981 punitive damages. But that's not all, okay? The best part, and the huge difference, at least in my mind, between a 1981 and a 1983 case is that in 1983 cases, upon the filing, you're going to invite a motion to dismiss as the first responsive filing, okay? And a lot of times those are going to be granted for one reason or another, okay? Now, in 1981, it's harder to win on a motion to dismiss at the beginning. Eventually, the other side is going to try to file a motion to dismiss, and if they lose, then they'll probably either settle the case or you can proceed to trial. But it's hard to win a 1981 case early on because there's so much evidence that has to be introduced. You've got to prove your implied contract, right? You've got to prove, sometimes you have a written contract. Then you have to give evidence on what the reasons were, why were you denied the privileges of the contract. And that's not information that's necessarily going to be available on the day that you file the case. So a lot of judges are going to let you do some discovery. If there is a motion to dismiss filed, they'll let you do some discovery to find out what evidence is out there to support the facts of your case. And there's no generalized immunity. There is no official immunity. There's no qualified immunity. There's no absolute immunity defense in a 1981 civil rights case like there is in a 1983 case. Is that right?
Yeah. So, I mean, I think that's good. I mean, so one thing I'll say, I love 1981 because of that, that it's a little bit more tougher to, litigate, which means that, there are more opportunities for a good plaintiff's lawyer, right, to fight this. Other reason I like 1981, that's George and I were both born in 1981. So we have that connection.
Very good here.
But the history, so I'll give a little bit of background. And, George talked about what to expect. We gave the example of, going to a restaurant, public accommodations, you get kicked out of a nightclub because, hey, you're a black man and you're wearing jeans, but the white guy is allowed to come in with jeans, right? And so that's another example. Or a hat, we've seen litigation in Houston regarding hats, whether, minorities can wear hats versus not. So those are all sort of the typical. The other real example that gets to 1981 is employment law cases. So there are a litany of laws, state and federal, regarding rights for employees not to be discriminated on a protected class. And by that, I mean race, religion, sex, veteran status, disability, whole bunch of protections you have, right? This is part of it. 1981 is also used to sue companies if they're discriminated against you. There are some benefits. It's for any employer, whether size of one. Most of the other federal laws require you to be slightly larger as an employer, right, in order to take effect. So let me just, before I jump into sort of that, the practice and the nuances of the law, the history of 1981. So I always tell, and I was an ethnic studies major in undergrad, Asian American studies at UT. We talked a lot about the history of race and race relations in the country from day one, right? So I always tell, my kids or anyone who listens to me about this topic, America has birth in 3 years, right? It's not once. Everyone talks about 1776 when the Declaration of Independence was written. Yes, that is a very important date. That's for the first time that this country stood up for its rights and said that, hey, people have rights which are not granted by the king, but granted by the Lord. And of those, you have, equal rights and civil rights. 1776, obviously, when the Revolutionary War starts, that was a gamble. It really didn't come through until the Constitution, 1780, 1787, is when the Constitution gets ratified in the country. This week was Constitution Day, which we celebrated earlier this week. But that really didn't establish the protections for all people. While it says, all men are created equal, it really meant white men and really white landed gentry, right, were created equal. Right? So you fast forward, we fought a huge war, the Civil War, 1866. So 1865, Abraham Lincoln is assassinated right at the end of the Civil War. America, or the Union, is trying to bring back the Confederate States back into the fold. Reconstruction is going on, which goes on for almost a decade, a little bit more than a decade, trying to bring the southern states, which had rebelled, back into the fold of the Union, right? As part of the Reconstruction, you had a very, progressive wing of the Republican Party, known as the Radical Republicans, who said that it's not just enough to free the slaves and say that, hey, you can't have slavery as per the 13th Amendment. You have to give certain rights to the newly freed slaves, right? So around that time, the Civil Rights Act of 1866 comes out. It's one of the first, probably the first Civil Rights Act that really addressed non-white landed gentry, right, in our history. And out of that came out 42 U.S.C. 1981, which talks about the rights, because the idea was at that time, you have all of these, free slaves predominantly in the South. Some of them were also, were starting to move up to the North. Well, they would just be denied the privileges of being a citizen, right? They were given, they went from, unfortunately, being treated as property to now finally being given the rights as human beings, right? 13th Amendment, 14th Amendment, 15th Amendment come out around the same time. But Reconstruction ends, and, for better or worse, the southern states, the former Confederate states, sort of went back to normal practice, right? They found other ways to the Jim Crow laws. You have all these concepts about separate but equal. You have, force, whites only can drink at a fountain and blacks only. You all have seen this, right? So You then jump another 100 years or so to the 1960s, right? Civil rights movement comes back, and the civil rights says no, no more, right? This law was already on the books. It had been applied in some ways up to that point, but really the Civil Rights Act that came out in the 1964, right, really is what we stand on jurisprudence today, right? That's the main thing. Title VII, and you hear about a lot, that's employment cases. Title IX talks about schools. Title II talks about public accommodations. These are all chapters in the Civil Rights Act of 1964. But 14.2 U.S.C. 1981 is talking about the Civil Rights Act of 1866, almost 100 years prior. So you'll see that. I feel like, where we're heading to today, all of the stuff going on in the news and social media, we may be getting another rebirth. It's 100 years is not that far away from the last time we had this. And basically every 80 to 100 years, America sort of says, look, we can be a more perfect union, right? And this is one of the ways they do that, right? But that being said, it's pretty interesting what's going on, sort of in the news regarding civil rights. We're seeing the DOJ being used to sort of abolish a lot of DEI, diversity, equity, and inclusion programs. Affirmative action is sort of now, I think, probably legally on its way out. Supreme Court has come out and said this. But this law actually encapsulates not affirmative action, not diversity, equity, and inclusion, but just saying that all citizens, regardless of your race, should be entitled to the same rights under the law, right? And I think that's a very, very honorable thing, and I think, as we litigate these issues, that's what we're trying to do. It's not, it's the love for this country. A love for civil rights is why we do it and why I do it, right? So let's just, before I transition back, let's talk about, the kind of scenarios you would see. So George, if you want to talk about some different scenarios where somebody thinks to have a claim, how would you say you're being discriminated on and in violation of 1981?
Yeah, so just going back to the restaurant example, that would be one context. Another one could be if you're at an airport and you are suddenly searched or pulled out of line or not let on your plane. We'll go with that one. People have been kicked off planes for complaining about one thing or another to a flight attendant, and the flight attendant, who in a lot of cases is not of color, will recommend to the captain and or security, get rid of this person because I don't like what they said. And 9 times out of 10, that person is of color. And I've seen one case where the plaintiff and the plaintiff's companion who did nothing, just they were in a couple together. And I think the flight attendant had an issue with same-sex couples. And they were of color and they were booted off the plane. And they ended up having to take another flight later that day. So that's going to be an example of how in a restaurant or dealing with a service provider, that's going to be an example of when you would see it. But you also have employment examples, right? And I think one example that we've come in contact with is we had a gentleman who was applying for employment and was denied. He was otherwise qualified, had all the qualifications for this particular job, but because of his facial hair, he was denied a position, and we successfully used this statute in that context to get him compensation for that denial. So, America is sort of a melting pot, and I mean, it's a giant melting pot. Everyone practices their own religion. Some people practice no religion. And so this particular client, it was just part of his religion that, he had facial hair. You see this in many different religions, actually. And there was just no agency policy. Well, there was an agency policy, I believe, that they failed to follow, which was one issue. But you can't discriminate against any member or all members of a particular religious background because they choose to have facial hair. And then there are other religions where you're not permitted to have facial hair. Your hair needs to be cut down to a certain level. That can be another potential scenario where you're going to see a 1981 claim pop up. But I mean, they're difficult claims to immediately defend without some discovery. Policy manuals like video surveillance, depositions, just good old asking questions and discovery, what we call written discovery and getting answers. You're going to have to go through all of that because, one thing that an employer can do if they are sued is to say, hey, we had a legitimate reason for making that employment decision. And that reason was race neutral or non-discriminatory. Or it had some safety feature to it that we just can't help it. So there are a lot of ways that the employer can try to slide out of liability for a claim like this. But if you're talking about someone's religious background, their national origin, their race, if you can ground the allegation sort of in the decision was made based on one of those three subcategories, it's going to take some discovery to try to disprove all that. Because just about every employer is going to have a policy manual, right? And sometimes employers follow policy manuals, sometimes they don't follow policy manuals. But it's more than, hey, you didn't follow your policy manual, which is more like a negligence claim. There's a standard of care, you set your own standard and you failed, okay? This claim goes beyond that. You have to prove that they discriminated, meaning it was their intention to bring about the adverse result because of one of these backgrounds. So I think, these are, and trying to connect that to today's times, you do see it a lot on travel itineraries, and people are trying to travel, and someone gets booted off of a plane for one reason or another. Sometimes even the elderly may not be permitted on the plane because they have some kind of an ailment that requires some sort of additional help that honestly they don't feel like giving. It's not they can't, but they just don't feel like giving. But the one case that came up was the one that the same-sex couple, it ended up both of them were booted off the plane. Only one of them had an issue with, I don't even recall what the issue was, but there was a bit of a back and forth with the flight attendant. The flight attendant said to security to remove the one, and they took both. So I think that's a pretty strong claim that they would have there.
Right.
But yeah.
No, and I think one of the difficulties in the law and the elements is you have to prove the intentional discrimination, right? And that is a very fact-intensive, process, and to get there, we are in the Southern District of Texas here in Houston, which answers up to the Fifth Circuit Court of Appeals, and then goes up to the U.S. Supreme Court, because this is a federal statute, right? So, what issues do you see with we had one not too long ago, arguing, and I remember, the conversation was, how do you show that the action was taken but for the race of the person, and how do you show comparative analysis? Because, right, the jurisprudence in the Fifth Circuit sort of looks for comparing it, because when you get into the weeds and you get into this, you get beyond the first stage, you file the lawsuit, right? The other side may or may not file a motion to dismiss at that stage. Usually here, you should have some fact element which is up to doubt, right? Which means that you probably will survive the motion to dismiss as long as, your lawyer hit all the requirements. But then you get into discovery, right? And discovery is the longest part of the case. At the very end of it, either you go to mediation, you go to some sort of settlement conference with a magistrate judge, or, or getting ready for trial, right? But usually, one of those things has happened. And the question is going to become is, in your discovery after months and months of going through this process, did you show that truly that your client, usually a minority, was treated differently from others? Where's the data that supports that? And were you able to show something that said this was not just a legitimate reason? Was the person acting up? Were they a security threat? Is that really why they got booted, or was it because of their race? Right. So that is something that if you work with a smart lawyer on how you assess, right? Because you have to show intentional discrimination, which is a pretty high standard, and you have to get beyond the but-for causation, which is really applicable in our circuit. You typically don't see a 14.2 U.S.C. 1981 pled by itself. Usually there are other causes of action. It gets you into the federal court, which is seen to be more favorable jurisdiction court for litigating these issues. But you might have a negligence claim. George was talking about not following a policy or a standard of care. That might get brought into it. You might have other causes of action. Typically, we don't see people plead to federal civil rights actions at the same time. So 1981 in a Civil Rights Act, it's usually one or the other, and that depends on the size of the employer. But if you have, again, the most likely scenario would be a place of public accommodation where something happens to you based on the race, right? Or maybe you work at a small employer and you want to bring this in because they're otherwise exempt from the Civil Rights Act, right? So those are two scenarios. I mean, I think we'll see, we can also see there was a promotion, again, I haven't seen it growing up, but I remember, hearing, hey, don't come to this location if you're Black or minority or something like that, right? The signs that used to be up, we all see in history classes, no dogs and no Irishmen, or, Blacks do not enter and stuff like that. That would be another example. Again, thank God we're not seeing that kind of overt racism here. But it's something TBD, right? As the Supreme Court takes up these cases and sets out where it is. But really, I mean, I think my practice points would be: you want to do a really good job on the initial investigation. You really want to figure out what is happening to other like-minded or like-placed people, right, who are of different races, and really try to attack that. And that's, I think, where an expert can come into play. We had a lot of litigation with fast food restaurants, again, going back to that. They post everything. Their websites and their corporate websites has everything, and you're really able to do a lot of good digging and figure out, what is their policy? What is your official statement, right? There was, just that reminds me, Papa John's a few years ago. He used to be in all the ads, the founder of Papa John's, and then he was caught on recording using the N-word, right? And they really quickly booted him from being, the official spokesperson of Papa John's Pizza. I think he was the large shareholder. So he stayed on. But that would be, damning, right? For Papa John's, you're calling people the N-word, right? And I think that's why the board of directors did what they did, because they realized the liability that could flow, for having.
And I don't eat Papa John's. I'm a Pizza Hut guy.
Right. So, but
cowboy hats. You talk about cowboy hats.
We can.
So there is a case that came out in our district. We're in the Southern District of Texas. A gentleman goes to a restaurant bar wearing a baseball cap, and he's told baseball caps are not allowed, and he doesn't want to take it off, I don't think, but he ends up leaving for one reason or another, and then brings a lawsuit and says, hey, I saw folks who were in the establishment who had hats on, and I had a hat, but my hat wasn't allowed. So the court issued a decision saying, okay, you had a baseball hat on. It's okay for the restaurant bar to have a policy that prohibits baseball caps. But the other people you're talking about had cowboy hats on. And because cowboy hats are a different type of hat from a baseball cap, and the court actually went into how a cowboy hat was made, how it was to be maintained, how it has to be stored, and basically gave a special protection. And maybe it's just because we're in Texas, but gave a special protection that said it's okay for these folks to be wearing cowboy hats inside of the restaurant, all the while the restaurant is banning folks who are wearing baseball caps. So that's why I say in Texas now, and especially in Houston, cowboy hats have a special protection. You can wear them pretty much inside anywhere. And if anybody kicks you out because you have a cowboy hat on, you now have at least one decision to bolster your case. So that concludes episode 4.
Or so. And then that reminds me of, Shabuzi, right? So if you're Shabuzi wearing your cowboy
Love
hat,
Shabuzi.
bring that on. But, don't be wearing a baseball cap like gray or something. But anyway, but no, well, thank you so much for joining us, and hit like
and follow,
and
please.
subscribe us. We are judging you. Episode 4.